I'm honored to speak to such a distinguished group. I do so with some trepidation. I'm mindful of the old story about the fellow who died in the great Johnstown flood of 1889. His name was George, if I recall correctly. Upon arriving at the pearly gates, George wanted to impress upon everyone the magnitude of the flood and its horrors. To spare George the need to repeat the same story endlessly, the angels who greeted him gathered together all the residents of heaven, so that George might describe the disaster to all of them. George rose to speak. One of the angels whispered to him, "Remember, Noah is in the audience." I guess it's a week for rain and a day for conundrums. The opening slide of my presentation, which is not up there, there it is the Erisa Conundrum. I do not intend this as an homage to Robert Ludlum, the author of such popular books as The Bourne Identity, or The Osterman Weekend, or the unforgettable Gemini Contenders, but as a way of introducing the subject of my paper. ERISA is generally regarded as a regulatory statute. It's designed to protect the rights of plan participants to employee benefits. But while ERISA is designed to protect the rights of plan participants, ERISA does not require employers to offer plans to their employees. While ERISA protects the rights of plan participants to the benefits they earn, ERISA does not give any rights to employees who are not plan participants, and it allows the employer to decide who participates in the plan and what their benefits are. Because of its strict regulatory provisions, ERISA could actually discourage plan sponsorship. When it enacted ERISA, Congress recognized that a statute intended to protect employees could actually harm them. As a result, ERISA was designed both to regulate and to cultivate employee benefit plans. I think we're going backwards. There we go. For example, the legislative history of ERISA reflects Congress's intent not to apply the vesting rules to welfare benefits for fear that requiring vesting would discourage employers from offering welfare benefits. The text of ERISA also demonstrates Congress's intention to limit the application of ERISA's fiduciary standards. The definition of fiduciary treats as fiduciaries only those who have discretion regarding the plan's management or administration, leaving out plan design decisions, which are now generally recognized not to be subject to ERISA's fiduciary duties. Many issues have arisen under ERISA because of the tension between the statute's regulatory objectives and its cultivation objectives. This is evident from many of the Supreme Court's most prominent ERISA decisions. The benefit claims decisions, Firestone and Concrete, for example, make clear that the courts are to defer to the discretionary decisions regarding benefit claims if the plan so provides. Its preemption decisions, Pilot Life and Egelhoff, for example, make clear that states are not to complicate plan administration by regulating employee benefit plans. The Supreme Court settler function decisions, like Lockheed and Hughes Aircraft, make clear that settlor decisions are not subject to ERISA's fiduciary standards, and its plan document decisions, like Kennedy and McCutcheon, make clear that employers have the right to set general rules regarding plan administration that are binding both on administrators and plan participants as long as they don't conflict with the terms of ERISA. The Supreme Court is now being asked to resolve the tension between plan regulation and plan cultivation in yet another case, Fifth Third Bancorp versus Dudenhofer. I should make clear, in the interest of full disclosure, that my firm represents Fifth Third Bancorp in this case. I'll try to be as disinterested as my temperament allows. The plan in the Fifth Third case is one that most of you will be very familiar with. It's a 401k plan, 20 investment options. Employees could invest their own money in whatever fund they wish to. The employer matching contribution went into company stock, but the employees had the right immediately to transfer out of company stock. And that was not in response to legislation that was in effect before the Pension Protection Act mandated transferability. This stock, as you might expect, declined markedly in value during the financial crisis of 2008 from over $20 a share to roughly $2 a share. I might add, parenthetically, it's now back up to over $20 a share. The plaintiffs in the case made a number of claims, but the claim before the Supreme Court was a prudence claim. The claim was that the fiduciary should have either removed company stock as an investment option or at least told employees that it was a bad option and encouraged them to shift out of company stock into other investments. Claims like this have been made in many, many other cases. And in most cases, until this one, the courts of appeal, in all cases until this one, the courts of appeal have dismissed the claims on the ground that even if the plaintiffs could prove everything they alleged, there was no basis for a claim under Erisa. It was a motion to dismiss for lawyers. The Sixth Circuit, however, overruled the district court in this case, said the claim should be allowed to proceed. And that's why the Supreme Court took the case. There's what lawyers call a circuit split between the Sixth Circuit and every other circuit that has addressed the issue. The defendants, the company, and the fiduciaries made four basic arguments to the Supreme Court. One is that the text of Erisa does not contemplate a claim like this. The prudent man rule sets as a standard an enterprise of like character and like aims. And the stock fund here was an ESOP, so the point is, what's an ESOP supposed to do? It's supposed to invest in company stock. The second argument was based on the legislative history. Congress has encouraged employers to offer company stock to employees. In fact, after the Enron debacle, Congress looked at the issue again, and its solution was not to forbid company stock investments, but to require that employees have the right to diversify out and to be informed of the right to diversify out, which was done in this case, and there's no claim to the contrary. The third argument was that this is consistent with basic trust law on which Erisa was built. There's a deviation doctrine of the common law of trust that allows a fiduciary to override the terms of the plan with court permission if the basic objectives of the plan cannot be met by doing what the plan requires. That showing was not even alleged in this case. And fourth, the defendants argued that the basic claim here is based on the proposition that the fiduciaries had material non-public information about the company and that they should have acted on it to advance the interests of plan participants. That the defendants argued, would have caused the fiduciaries to violate the federal securities laws. Rule 10b-5 for the lawyers. And can't possibly be an obligation. Fiduciaries are required to act in the interest of participants, but not to break the law. Can't steal from party A to benefit party B under ERISA. Suffice it to say, the plaintiffs have vigorously contested each of these arguments. The oral argument was held in April. Expect the decision in June. People ask me how the argument went. I would say it was a spirited argument, to say the least. I'm in no position to predict the outcome. One prediction I will make with some confidence, not a high level of confidence, is that there'll be votes on both sides. So even the losing party will have some votes to show for its efforts, but I'm not prepared to tell you or to predict who the losing party will be. Thank you.